Number 204, the people of the state of New York versus Patrick Morgan. Good afternoon, counsel.
Good afternoon, Your Honor. With the court's permission, I'd like to reserve 2 minutes for rebuttal, please. Yes.
You may.
We contend that there were 2 very serious errors that occurred in this case at the most crucial time of the case during deliberations. We believe that each independently requires reversal, but they also worked with a prejudicial synergy. After this jury declared itself hung and got what we acknowledge was a perfectly fine Allen charge that was balanced, the jury then came back 2 hours later and came in with what the foreperson said was a unanimous verdict. Polling revealed it was not. The 2 jurors who disagreed with it were therefore, as we put it, outed. It was therefore
Counsel, if the court had just said, I'm sending you back, I gave you my instructions a couple of hours ago, proceed with deliberations, have you got a violation at that point?
If he would have said that.
Yes, and then didn't go into detail on
Yes.
one, we'll call it one Allen
Yes.
prong for the
Yes,
moment.
that would have been perfectly acceptable because that would have
Saying
been,
less would have been okay.
well, not just that, Your Honor, but because it would have been an explicit reference to the charge that I just gave you
That was complete.
a couple of hours ago, which was the acceptable, balanced hung jury discussion. Instead, and in fact, I'm glad you did say that, because that instruction itself also included the unanimity instructions.
But you didn't even want that instruction, right? The earlier instruction you didn't ask for.
Well,
I think both parties didn't want the judge to instruct the jury about continuing to deliberate in the kind of a reduced Allen charge. And the judge, as I understand it, sua sponte, decided to
the
give it.
first time around.
But now
yes.
you're saying that that was the right charge then,
Well, that was the right charge then, but our error that we're talking about is what
right?
is
And you,
what
at
is
this
appropriate
point,
now.
asked for a mistrial.
That was among the relief that the
Well,
counsel...
first, you asked for a mistrial.
Yes,
And then the judge gives them this instruction, and they leave.
and then, after that, but to that, counsel then engages with the court in a lengthy colloquy that it is set out in our appendix at
Before you get to that,
I'm sorry.
I'm having a hard time understanding
Okay.
what you think was coercive about the court saying, I'm sending you back to try, to attempt, I think you used the word attempt, to reach a unanimous verdict. What is coercive
what was
about that?
wrong-
What needs to be balanced in that?
What was wrong with that was, and what counsel asked for, and no one complained about it being late or anything else, so that is waived, and the court knew what counsel was asking for, was a resurrection of what the court had given the first time around, which was, you can stick to your beliefs.
My understanding is that you need the balancing when you suggest to them that they must reach a verdict, or when you single out the dissenting jurors, or something of that nature. Then it needs to be balanced. Here, I just don't understand what needed to be balanced when all that was said was, I'm going to send you back because it needs to be unanimous, and I want you to attempt to reach a unanimous verdict.
Well, I would say in these particular circumstances, once you've had a hung jury, once then you've had identified jurors who disagree with the verdict, then, as this court noted in Cassoon, where you have to, where they labeled, that would have been an intelligent suggestion there to be solicitous of the 2 jurors who are in the minority there. What you have here is the need for balance because...
But what are we balancing?
Okay. What
That's
we're
my
balancing
question.
is the repeated statement in the charge that all 12 jurors must agree, I'm not going to accept this, I'm going to order that you go back and resume in an attempt to reach a unanimous verdict. That is where all 12 agree. All that is said there is the emphasis on unanimity. What needs to be balanced against that is, and especially where you have identified jurors in the minority who don't agree, that you have the right to stick to your beliefs, that you don't need to reach
So
a
you're saying
verdict.
the message that was sent, because one verdict had already come out that was not unanimous.
That's correct.
Is that you all have to be unanimous. Get there whichever way you want, but you all have to be unanimous.
It was-
As opposed to, if you don't reach unanimity, somebody's going to come back and say, I just can't sign on to that verdict.
Yes, what we're saying is, effectively, this was almost a repetition of the hung jury declaration. We have a jury that was given a balanced charge the first time around. And then, we don't know what went on in that jury room, but obviously, ultimately, two of those jurors summoned their courage to say, yeah, we've heard all that, but we don't agree. It's not our unanimous verdict. We don't agree. So at that point, heightened judicial sensitivity was required.
But we can't assume that because they just heard that balanced charge a couple of hours earlier, not the day before or 3 days before, a couple of hours earlier, we can't assume that they heard and understood that charge.
Well, first, the fact that they were given that balanced charge when they were given it, and then they come out and they obviously haven't, there's been an announcement of a unanimous verdict, but it's not
So
been
they
rendered.
followed the charge.
But this, I'm sorry,
They followed the charge. I mean, they came out and they said, no, that's not my verdict, so they were following the earlier charge.
but the charge that was subsequently given, though, it referenced the final charge, not the one that they had just heard. It referenced only before I sent you out to deliberate, my closing instructions to you were how to deliberate. If you look at those instructions, in fact, they say nothing about stick to your beliefs.
How
It's just
coerced could
not
they be?
unanimity.
They went on to deliberate for quite some time.
As the cases recognize, and this court has recognized in Aponte, that the length of deliberations is not dispositive. Obviously, it can lend help or support in finding coercion, but the fact of length doesn't mean that the charge itself that was given is fine.
No, but it does go to coerciveness, doesn't it?
No, what it could say is, and as I think the circuit is recognized, and I only cite it because I think it's supportive of what this court said in Aponte and gives teeth to it. Why is it that it's not dispositive? Because we don't know what goes on in that jury room. And the fact is, those two jurors who finally summoned the courage during polling to say, no, it's not us, but how do we know? Should we judge a verdict by their fortitude or what goes on?
So you're advocating a rule that whenever there is a split verdict,
yes.
then the entire Allen charge has
I'm
to
not
be
saying the entire Allen charge. This is what I'm saying. In this particular case, and we do have a governing statute, 31080, where when a jury renders a defective verdict, such as this, for example, it can simply tell jurors, resume your deliberations. That's neutral. It says nothing. But when you have somebody, as here, the judge, who doesn't do that, but now just simply focuses on, you need a unanimous verdict, try to do that, you need 12. If you are going to go that route, if a judge is, then you do need to hew to balance, which is, and give a gesture toward the prior instruction that you gave about you don't need to absolutely come in with a verdict. And remember what I said, do not surrender conscientiously held beliefs simply for the view of...
Counsel, you seem to be saying there are two different issues here, right? There's the deadlock that happened before, and now the not unanimous verdict. But they happen, you seem to be saying that they happen in such succession that they kind of get merged together.
I'm not saying that in this way, because what we have now are different circumstances, and that's what's critical. We now have, when the jury renders the defective verdict, we now have the public identification of minority jurors. If anything, they should be given, if a judge is going to go the route of doing more than simply saying resume deliberations, which then would be without making any choice about, you shouldn't, that explicitly is saying or implicitly is saying, remember what I told you before a couple hours ago when you were deadlocked. It's not saying don't use those instructions, it's just simply saying resume deliberations. But whereas here you have a judge who is then emphasizing the need for unanimity for a verdict, if you're going to do that, in the circumstances here now where you've got identified jurors in the minority, it's then incumbent to have a balanced instruction that says to them, and you shouldn't, again, as I said, there is no need to give up, and you shouldn't give up conscientiously held beliefs simply to achieve that unanimity. It's all the more important, and as the cases recognize, as this court noted would be an intelligent suggestion in Kissoon, to have jurors be told that they don't need to give up their conscientiously held beliefs. And as I said, because they deliberated for a while, we don't know. I mean, obviously ultimately we have the verdict that we have. Maybe they just, they finally just gave up. Remember, this judge said, try to have a unanimous verdict. And that's what's important.
Thank you, counsel.
Okay.
Counsel?
May it please the court, Catherine Reno for the Office of the Bronx County District Attorney.
Would it have been different here if the court had said, you need a unanimous verdict, so I'm going to have you go back and continue your deliberations until you reach a unanimous verdict? Would that have been a different story?
Yes, that would be very different. Here, the court made clear that they only needed to attempt to reach any unanimous verdict.
So that's what you say is saving this instruction, essentially.
Yes, absolutely. The court didn't imply that a unanimous verdict was required, that they had to reach one. The court simply asked them to continue to attempt to reach that.
There had been no deadlock before, and the court hadn't given an Allen charge, and then the jury reaches a verdict which is not unanimous. Would you say that 31080, just go back and deliberate, would be sufficient?
It would be sufficient in that case. The trial courts have a lot of discretion in this area, and CPL 31080 simply requires that the court just send the jurors back and ask them to continue
But
deliberating.
now that there has been a deadlock just before, sometime before, and then a non-unanimous verdict, nothing different?
No, there isn't any requirement. The fact that it's a deadlock note or a non-unanimous verdict, it's up to the trial court in its discretion to look at all the circumstances of the case and the context to determine what type of charge to deliver. For instance, here, it had delivered the full comprehensive Allen charge 90 minutes prior to this non-unanimous verdict. So it was up to the trial court to decide whether to give another
Right,
comprehensive.
but then they heard that instruction. Let's say they took it to heart, they went in, they deliberate, they come out, and they're not unanimous. Isn't that their understanding of that instruction being, we're trying to reach unanimity, we can't, this is the best we can do, and here we are, and then the judge says, you have to go back. And I understand your point that the judge says attempt to reach a unanimous verdict, but that's only after having said very clear, I told you that your verdict as to any count of the indictment that you consider must be unanimous. That is, all 12 jurors must agree. Therefore, I'm not going to accept this verdict. I mean, that sounds like a very strong statement from the judge
Well,
after people have come back, having heard the Allen charge, having heard the instructions,
right, but
that you've got to get to 12.
But this verdict wasn't unanimous. They said they had reached a verdict, and in actuality, all 12 didn't agree. So it seems to reflect more of a confusion, perhaps, on the part
As
of
to
the
what
jury.
constitutes a verdict?
Exactly, and that's why the court said in its supplemental charge here, that means all 12 of you agree. So the
Because they
court-
came out and they said, we have a verdict, right? And then they said it was 10-2.
Right, so it probably reflects confusion because before, when they had been deadlocked, they sent a note saying that they were hung. So that shows that they understood they could do that if they felt that they were hung and unable to continue deliberating
But
further.
why not give the other part of this charge? Why not?
It's not
What's the
required in this
concern?
case. Well, the court didn't ask the jurors to re-examine their own views or target the minority jurors at any point. So there's no need for this to balance because there's nothing for it to counterbalance. The court isn't giving them any kind of coercive
Well,
instruction.
two people have, I think several people have already said, two people are now publicly visible as not being in agreement with the other 10. So they're going back into that room knowing that they're the holdouts or they're the minority at that point, right?
Yes, but again.
That's a coercive environment, isn't it?
It would be, first of
The
all.
judge sending them to a coercive environment without making clear that they need not fold?
Well, the court had already done that just 90 minutes prior. It's really.
Right, before they had publicly admitted that they were the minority.
Right, but the jurors can be trusted to follow instructions. I mean, it's up to the trial court
Yes, they can,
discretion.
and the instruction is, I told you that your verdict as to any count that you must be unanimous. All must agree. I'm not going to accept this verdict. Go bring me a verdict.
Well, the court did not say, bring me a verdict. The court asked them to attempt to reach a verdict. And the jury's response shows that it wasn't a coercive charge.
Right, but
For 8 hours.
isn't really the sentence you're referring to about the attempt to reach a unanimous verdict, really his explanation, apropos to your argument before, that it seems like they just didn't understand what's a verdict. So the judge is telling me that's where all 12 jurors agree as to any count submitted to you. He's explaining that. He's saying that's the verdict. Verdict means 12. Go get me a verdict.
He says, I'm going to order that the 12 jurors go back to the jury room, resume your deliberations in an attempt to reach a unanimous verdict.
That is where all 12 jurors agree.
Correct.
Isn't that an attempt to explain to the jury what they
should attempt to do?
What they didn't appreciate, which is that 10 out of 12 isn't a verdict.
Right, and he's asking them to attempt to reach that verdict where all 12 of them agree. So, again, it should be pointed out that we're not sure what the two
You don't think that puts pressure on the other two to fold? Or to persuade the other 10 to agree with them?
No.
Because that's what gets you a verdict, 12.
No, because the court is only asking that they attempt to do that. It doesn't matter that the court knows the breakdown. There's absolutely no case law that says the court, once it knows the numerical breakdown, has to give
You needed
this
to say if you
language.
don't get to that, it's fine. If you cannot get to that, it's fine.
No,
You don't
there's
think
no
this is sending
requirement.
the message, you have to keep working until you get a verdict? He's not, I agree with you, he's not, the judge is not suggesting what should be the verdict.
Right, but no, there is no, case law doesn't require that. And again, because it didn't obligate any jurors to re-examine his or her views in light of the other jurors, whether that's the minority or the majority reconsidering. And we don't know here what these two holdouts, if they could very well be holding out for a higher conviction, for a conviction on murder too. We don't have a record here. Defendant has not provided a sufficient record to show that we can assume that they were holding out for an acquittal.
Counsel, do you care to address the jury's request to hear the defense summation?
I do, Your Honor. Thank you. Defendant here is belatedly raising an ineffective assistance of counsel claim as a subterfuge to obtain review of his admittedly unpreserved claim that the trial court erred in refusing to read back the defense summation. This issue isn't reviewable on direct appeal. As the appellate division found, we need to have a 440-10 motion in this case. There's no time bar. It would be very easy for defense to file that, and it wouldn't force the court to consider this based on supposition and conjecture.
But doesn't the record, what is it that you think is not clear about the record, right? The judge is saying that's not evidence, and the defense attorney is saying, you're right, that's not evidence.
Well, it isn't evidence. It's a correct
No,
statement
I
of law.
understand that, but isn't that the judge's reason for it, as opposed to, let me consider whether or not allowing them a readback of summation would be appropriate?
Regarding, are you asking about the court or defense counsels?
Let's start with the court.
Well, the court says it's going to decline to do so. The court doesn't say, I'm going to deny because it's not evidence. It doesn't expressly agree with the people. It says this is the court's feeling. It says it's going to decline to read it back 4 times. So it is indicative, that's indicative that the court was exercising its discretion. But this issue isn't so clear-cut. This court's holding in Velasco was only that the defendant hadn't preserved his claim.
I thought the prosecutor says, obviously, when asked by the court, it's not evidence, and I would ask that Your Honor instruct them that due to the fact that it's not evidence, it will not be reread to them. And the court says, that's the court's feeling. Isn't that saying, that's my ruling, that because it's not evidence, I won't have it read back?
We don't know.
What do you think I just read means? What do you think this means?
It doesn't necessarily mean that the court didn't expressly say, I'm not going to read it back because it's not evidence, so I can't read it back.
Let's say I
We
don't
can't
agree,
know.
let's say I don't agree with you. Or the court doesn't agree with you.
Okay.
What's your next argument?
Well, this issue's not reviewable, so if we bring it back into the realm of ineffective assistance of counsel, even if defendant would have raised this objection, the court likely, or even if the court would have given the read back, it's not clear that it's not so decisive. The defendant can't show a link between having the read back and the verdict in this case. They continued to deliberate. They asked for other evidence to be read back. So we don't know that this was such a determinative issue. We don't know which jurors asked for the read back. We don't know why they asked for the read back. All of it is pure speculation. So this isn't a clear-cut issue like a meritorious statute of limitations claim or something to that extent, where it's very clear that one error on behalf by counsel tainted the entire representation. Defendant was acquitted on the top count in this case. He was acquitted of murder too. Counsel was effective, and this simply isn't the type of single error that was ineffective. So.
Thank you, counsel. Thank you. Ms. Salomon?
Yes. First, with respect, if I might, with the juror coercion issue, yes, there is case law that supports our position. Smalls v. Batista, obviously, in our main brief and also in our reply brief. This court's noting in Kassoon, for example, that it would have been an intelligent suggestion for counsel to have requested solicitude for the two jurors in the minority and that they need not give up conscientiously held beliefs. Also, all of the other federal cases that have trucked with this issue have all, when they have affirmed, have done so because the instruction, when jurors were singled out, explicitly referenced the other instructions that talked about no need and please do not give up your conscientiously held beliefs.
But could that be a function of how long ago that instruction was given? I mean, isn't really it a facts and circumstances case? So if the instruction's a half hour before, do you maybe not have to say those magic words as if it's 2 days before? You say, remember that instruction I gave you 2 days ago. I mean, it can't be that those are just the magic words you always have to put in there, no matter how recently the jury was instructed on that issue?
Well, the fact is that they were instructed on there in this case, and then they came back with a defective verdict. So whatever it was, it didn't work.
But you could
now we
say
have a new
it
circumstance.
did work,
Well,
because if you polled the jury and they said yes, and then later they came in and said I felt coerced and I had to say, yes, then it wouldn't have worked. But here, they didn't give up those beliefs, and in fact, in open court, adhered to them.
So, well, and the fact that they did, they therefore required some support by the court, not a reference to simply unanimity instructions, which is the one that they heard predominantly in this case. They heard it at the final instructions before they were sent out. They heard it at the hung jury determination, and then they heard it again. That's the one thing that they repeatedly heard. But as these cases discuss, Smalls in particular, and then other cases that have followed it, again, talk about we need to look at things from the minority juror's point of view, having been outed. With respect to the readback request, I think I addressed in my reply brief that we've not raised a subterfuge claim. We're perfectly entitled to raise ineffective assistance. Here, everybody was just wrong on the law. Velasco has been this court's law since 1991. A quick Westlaw little charge, little search would have picked up the case immediately. Also, defense counsel had no strategy. He just was ignorant of the law. This court's decision in Nesbitt controls on that. Even if there could have been strategy, the fact is
didn't he say something like, whatever you decide, I'll. So doesn't that indicate that he may have realized that there was that there was some discretion there?
No, Your Honor. Everybody is singing out of the same hymn book, which is it's not evidence. And all he says is, I know it's not evidence. So he's just agreeing with the other two parties, the court and the DA, who have all said it's just not evidence.
And what's the effect on the verdict?
I'm sorry?
What's the effect on the verdict?
Well, we don't need to show that. I mean, that's quite a hurdle. However, in this case, When you have, during deliberations, a jury who comes out, again, after this debacle, I would say, with the instructions, you then have a request, and they keep asking for evidence. So this is not a situation where they're just relying on summations. They've been trying to deal with the evidence, they myriad requests, and then they come back and they say, we would like to hear the defense summation. And by the way, I think any defense attorney would be, just say yes. Just say yes. That would be your defense position. Let someone else say why they shouldn't get it.
Couldn't the defense attorney have thought, well, if they read back my summation, then the people are going to want them to read back their summation?
Your Honor, I think the answer to that would be, number one, fight your battles as you get them. I would say if they came back, this is what the jury asked for. As we know, juries don't always ask for everything from everybody.
But aren't you then second-guessing strategy when
No,
you say that?
no, there was no strategy. He betrayed ignorance of
Well,
the
that's
law.
the question that maybe a 440 might
I don't think so here, Your Honor.
Maybe the way the notes were coming out or what the deliberations were, he might not want his summation read back if he's arguing different things he's
Okay, if he's-
anticipating that they're not looking at.
If he said, I don't want it, if that's what he wanted, he need only have said it. Otherwise, he simply rolled the dice because he said to the court, I'll be happy to do whatever you like. Maybe the court might have changed its mind. This was not some nefarious, I hope he'll say yes, or maybe he means no. No, he said, I don't know the law.
Strategy, as Judge Stein was saying, aren't there possible reasons that he could have not wanted it
No,
read back?
that would be an unreasonable strategy. When you have jurors who are struggling, and they've come back and they asked for it twice. They asked for it, they made sure, they said, and can we please have the defense summation? Had they then somebody then asked for the people's, he might have opposed that. They said they didn't ask for that. On the other hand, we do know we have a juror who's interested in the defense summation. So
I
at least
just
give
want
them that.
and to acknowledge the intellectual validity of your argument. I think that 31030 does in some way support your argument, but I'm having difficulty with the preservation part of it, and then whether or not it's ineffective. But the argument itself, the language seems to say that the court may anything that's pertinent, so it just seems to fall within that category. But you have a much more difficult time on the preservation argument.
Well, Your Honor, I'm sorry,
With the preservation point, I think, and then whether or not this error is sufficient to get you over the hurdle.
are you talking about with respect to the ineffectiveness itself?
Yeah.
Well, again, you would just need to say that the court would have read it. In other words, had the court, we know that we had a non-exercise of discretion.
Mm-hmm.
So under Cronin itself, which is the lead case of this court about that, you don't need to show that the judge, under a proper exercise of discretion, would have necessarily done so in your client's favor. But here, we have all the arguments, certainly, that would have augured for a ruling in the defendant's favor. There was nothing wrong with the summation. This was actually quite a complex case, including even whether there was conduct that was non-intentional or whether there was a struggle over the gun. The judge actually said that in granting the request to charge second-degree manslaughter. So we have a complex case. We don't have a jury making this request basically in lieu of dealing with the evidence. They've had gazillion requests for the evidence. So they would just like to hear something that they haven't heard for 5 days. It's been a long time, and it was very complicated.
Thank you, counsel.
Thank you.